Hi, I'm George Dimov. I'm here with Iryna, and she is an estate and trust specialist. Estate and trusts are one of my favorite topics, and it's something that comes up with client questions every single day. This is one of the biggest topics being talked about right now in the United States because there are so many people that are baby boomers that are retiring. They're thinking about how the next generation is going to use their assets. They're thinking about tax implications. They're thinking about legal implications. So we'll jump right in. Iryna, maybe tell us a little bit about yourself and give us a little bit of an intro.
Yes, hi. Thank you, George. My name is Iryna Avrine. I'm a founder of estate planning law firm, Avrine Law Firm in Bethesda, Maryland, which I founded back in 2016, a few years after I became a licensed attorney in Maryland. At that time, I wanted to create a practice that was personal, one where clients felt comfortable talking about some of the most important emotional parts of their lives, and like protecting their families, planning for the future, and planning for possible disability or even death. Over the years, I worked with a lot of clients and a lot of kind of clients. We provide comprehensive services, estate planning, administration services for different kind of clients, such as individuals, married clients, families with young children, young families, families with adult children, various blended families, families with special needs members, and even international assets, pet owners, business owners, and retirees. So I'm very excited to talk about estate planning. That's my favorite subject, as I already mentioned, and let's talk about it.
So the one topic that comes up consistently is
Mhm.
what are some of the considerations that somebody should think about when they're choosing between a revocable trust and an irrevocable trust?
Yeah, so basically, in my practice, I usually so how we work with clients, we start as a so-called a fundamental trust planning. So most of my clients they need a planning around the like we do trust fundamental planning. So you can do the planning that revolves around the trust or planning that revolves around, for example, last will and testament. Most of my clients, we come up with the idea that we need to do trust planning around the revocable trust, and we call it the fundamental trust planning. We decide how the assets will be distributed, to whom assets will be distributed, and in which manner. And then when we're done with the fundamental trust planning, we took care of the financial power of attorney, advanced medical directive, and all other ancillary documents that needed for the client. And usually it's a lot of comprehensively drafted documents, especially tailored to the client's needs. Then we're going to look, or in the process, we'll look at other unique circumstances of the client's family or client's business or any other aspects of their life if they need additional trust, such as irrevocable trust. For example, if they want to provide some gifting to their beneficiaries that they want to keep in irrevocable trust, or maybe after speaking with the CPA or collaborating with financial advisors, the client come up with the idea that we need to have a life insurance trust, or maybe Medicaid as a protection trust, or any other irrevocable trust. Like I don't know, I'm just thinking maybe qualified domestic trust for someone who is not a United States citizen, or other trust. So yes, first we start with the fundamental trust planning. It usually involves revocable trust that every client should have, in my opinion. And then we see if we need to create any additional irrevocable trust or such a special needs trust for their children or other members of the family if there are some members of the family with special or supplemental needs.
Got it. And something that, and this is a little bit of kind of a niche topic, but I was reading the Wall Street Journal yesterday morning, and they had an article there, and I don't know if you saw this, and this is kind of something that is a little bit of a new trend now, is people are getting 23andMe and they're doing genetic testing, and now all of a sudden you've had people that had a secret child or a secret family or a secret relative that nobody knew about, and now they get somehow involved in this state. And I thought this was a really fun,
I
interesting
mean,
topic.
I didn't see the article, to be quite honest, but that's very interesting because I'm actually have a client right now who is concerned that he may be exposed this kind for this kind of stuff. Like I had some clients who used to be young students and were donating some of their sperm, and then I have this client who was hiding from the family and from his sons and others, like or family members, that he had a child when he was in high school. I mean, not here, like, in this situation, when we know this may be common, we have couple ideas how we can do it properly in the drafting. For example, for this client, I said, okay, how do you want to approach this? We can do it like really like soft disinheriting, in the sense that we can say, okay, I'm only providing for this particular family members or their descendants or their like my daughters or my sons and children's of my children, like specifically named in the documents, and everyone else is disinherited, like a soft disinheritance, like no hard feelings, but I'm only providing. And that's interesting for the fact that in Maryland, actually, you don't have to provide for your children. Actually, you can disinherit even a newborn. You may not disinherit your wife or husband, because there is like some inheritance that you still have to provide for your spouse, but for children you may. On the other side, if they want to disinherit it, no, hard way, I don't know if you call it. So we can say, look, when I was a child or when I was in high school, I happened to have, like, I don't even know if this person was born or like adopted or something happened, but I would like to make sure that these people or descendants of these people are disinherited as well. So like, or maybe they want to acknowledge, and they will be welcoming new members of their families. I don't know, but it's very important to acknowledge it one way or another in the documents, because if someone does come up, even if there were no proper, for example, like adoption provision, someone would like to claim inheritance, they can say, oh, the person knew about my existence, but he forgot to mention, so that's why it's very important to say, maybe acknowledge, okay, there may be other candidates, there may be other beneficiaries, but I'm not providing for them in my estate planning. So that's why I'm saying, like, estate planning always involves not only knowing how to properly structure the documents to take care of clients' taxes or, like inheritance, who inherits, why they inherit, and how much and when, but it's also to find a way to speak to the client so they can think through their goals and maybe some circumstances they didn't even think may exist. You know, that's a beauty of estate planning.
And for our audience, we had some topics that we were going to cover, but obviously what's more interesting is an article comes up about estates and trusts about people that had a secret family or that had a secret child. And this is a topic that I think it's something that is interesting for people, whether it applies or not. And it's very something that I noticed because I'm an immigrant, and when we first came to the United States, we saw the country had certain values that were family values, but then I think it was in the New York Times or some other major newspaper, they said, we have very conservative values here, but also we're known to have very messy families. And it said, and this is what
Well,
the, yeah.
exactly. And like, but why still, like, when we talk about estate planning, I remember that's, and actually how I got into estate planning when I was in law school is thanks to my law professor, who used to say, oh, wait a sec, estate planning is a happy loss, quote unquote, she said, because it's less about controversy. It's more about like family getting together and like, and deciding what is best for them, providing a roadmap, what if something goes south, and like, and just being on the same page and decide and talk about some stuff they might not necessarily talk on the around the Thanksgiving table. All right. But you're absolutely right. The families here are amazing, in the sense that there are so many blended families. I never knew. I'm also an immigrant, and like, and I was shocked how many blended families here, and how many and most of my clients, they want to provide for each side of the family. So, for example, in Maryland, why people ask, like, why do we need to engage in estate planning? One of the things I'm asking, do you have a stepdaughter or stepson? I have a stepdaughter myself from my husband's previous marriage. She's like adult now, but like when we got married, she was a little child. And most of the people say, yeah, exactly. I treat them as members of the family, as my own children. Like my stepdaughter was 9 when we got married, and and she became a daughter to me, even after I had my own children. But and of course I want to provide for her. Most of the family want to provide, but in Maryland, if you do not specifically name or acknowledge this child who is not officially adopted as your child on the paper, like you say, okay, I acknowledge this child from a previous marriage or relationship of my husband, but I would like this child to inherit the same as my children. I include this child in the reference of my children, then this child will not have to pay 10% inheritance tax in Maryland. So, but but you have to engage in estate planning to say that. If you don't, the stepchild may need to pay 10% if they inherit after you in
And
Maryland.
that's 10% to Maryland State.
Yeah, Maryland State. It's inheritance tax. It's actually when we talk with clients about estate planning, taxes come up all the time, and usually I discuss. Like I saw that you had a question for me, like how also when you talk about taxes, right, and estate planning come up really often, but same with estate planning, taxes come up really like every conversation I have with my client. Like even with initial consultation, we discuss four kind of taxes every time I speak with the initial consultation. For example, we talk about estate exemption, whether on federal or state level, and see. Most of my clients may not even they're not going over the threshold for this taxes, right? Because the exemption is so high at the moment. But still, like we may want to have some formulas in their trust document. What if the federal exemption amount changes or Maryland changes the exemption amount? So they need to know what the estate may be subject tax implication. Then we'll also talk about inheritance, Maryland inheritance tax, which is only specific to the Maryland, to the state of Maryland. Like if you want to provide some inheritance to someone who is not a member of your immediate family, and your immediate family in Maryland, it's only your children, your parents, grandparents, your grandchildren, and your sisters and brothers, your siblings. For example, your nieces and nephews are not your immediate family, and if you would like to leave some assets to your favorite niece, she or you will have to pay 10% inheritance tax in Maryland. Same for stepchildren, as we discussed at the beginning. But we can avoid this with stepchildren, but we may not avoid it with inheritance. Then we also discuss capital gains and how they come into play. Or, like do the clients get a step up on basis or not up on pass, and what's going on with the real estate or other assets. And of course, we talk about federal income tax implications. And when I see a large IRA or something that's going to be tax driven, I say, okay, now we have to have a CPA on board, financial advisor, to see if we need to engage more comprehensive planning for example, for tax implications, because I can draft the documents, but I need, CPA approval, so to speak. Like say, okay, I think we need this trust. We need to create sub-trust for grandchildren or something that can be beneficiaries of someone's IRA to sprinkle the income or minimize the tax consequences for the clients or client beneficiaries. So yeah, so to answer your question, taxes and and estate planning, they go side by side, and there are so many interesting conversation and so many blended families with different needs. So that's what makes my job really exciting.
And what's the just to remind the audience, because first of all, there was some changes recently with the federal, but just to remind the audience, for Maryland, what are the exemptions that they're looking at on inheritance for federal currently and for Maryland currently?
So for Maryland, it's $5 million per person. So currently, and I think it's gonna stay this way because it was gradually went up to that level a couple of years ago, and that's what I think is gonna stay at 5 billion. For federal, I would probably ask you for a correct for exact number, but it's about $15 million per person. But this may change. That's why like usually when I have a family, a husband and wife, where we can engage in some marital deduction plan and stuff, I would make sure that I have formulas marital deduction formulas in place. So maybe we have these formulas. If we need to use them, we're gonna use them. If not, so to be, because we don't know what's gonna happen, and tomorrow is not promised, but taxes. Right.
Right, that's right. And there's another thing to bring up here is that for some clients that may have a net worth that exceeds the federal or the state exemption, or at least on the federal side, you can stagger each a parent. Each if you have two parents and one passes and then the other one passes, there's ways to stagger this exemption. And so I'd imagine when you're doing the planning on the state side, you're also taking that into consideration. What about families that might have components of either the family or components of their net worth spread out throughout the DMV area? So obviously, you and I have a client base that we have a large client base in the DMV area, which is Maryland,
Mm-hmm.
Washington, D.C., and Virginia. So what do you do in cases where you have families that have more than one home, more than one workplace, more than one family member across these three states or more? What happens if somebody moved to California, somebody moved to New York?
So are you asking like what if you can actually do some changes in the trust? Like how I'm trying to understand the question. So what do I do if I have clients who have, for example, vacation home in South Carolina, or maybe like okay. So basically, I usually we have to understand where we do the fundamental planning first. Usually, if your driver license is in Maryland, so and if you pay taxes out of Maryland, so for as far as I'm concerned, I consider you a Maryland resident, and I would suggest a regular Maryland revocable trust. Saying that, like you may, the trust is just a document, right? It's a contract between you and yourself, like to arrange some assets and to provide to someone who's going to inherit your assets, and to provide in case of incapacity. But for trust to truly work, you need to fund it with your assets, or make sure that the assets would go to the trust upon your passing. So when we talk about real estate, so if you have a house or real estate in Maryland, so we would, as a Maryland licensed attorney, we can help clients transfer or retitle the asset real estate into the trust in Maryland. However, if the client has a vacation home, for example, in South Carolina, or like in our practice, and a lot of clients have some properties in Miami. So, like we would have to engage the Miami licensed attorney or South Carolina licensed attorney. And so they can prepare an assignment or type the deed of the house to the trust in Maryland. So the house works under the Maryland laws, but we have all the provisions necessary that when the client passes and the trust becomes irrevocable, and for example beneficiaries would be more comfortable removing this trust to another state, we have some provisions that you can change the status of the trust, so without changing the terms of the trust. So it's very interesting question, but like it comes to the point, like if it's a regular revocable trust for estate planning purposes, so you choose the state where your personal residence is located, you make sure you transfer this residence into your trust, and then you see if you want to transfer other assets from like South Carolina or other states, right, to the trust, or you may engage in some LLC planning, like if for example clients they have a rental in another state and they want to make sure that the rental is the other assets are protected from creditors issues of from someone claiming their property, or like something happened on this rental. So sometimes we engage and say, okay, let's create an LC, and then we assign an interest of the LC during life of the client or upon passing of the client to the trust. But during life, the property is held in an LC, to provide asset protection for the clients from different credits. That's when actually we engage CPAs, because the clients have to understand the tax implications here as well. Like, or how do they transfer the real estate into the LC? Do they need to pay extra tax? Who's going to be filing their tax returns for LC, or for any other asset protection tools? But yeah. So, but if the client moves to another state, they can actually, like we just had a client last week. She moved to North Carolina and getting married. She decided to take your trust with her. So we help you find a North Carolina attorney who reviewed the trust we drafted a year ago and said, okay, we just need to update some state-specific documents, and the trust good to go under the same terms of the Maryland law. So it's just, I guess estate planning is also, we don't have a crystal ball, like my law professor used to say, but we kind of, with experience and with lots of clients we have, and we learn and from them and through them what may happen, right? We
Now, I have
also.
a question for you. And this one is procedural. So and something that's part of the confusion that clients have when they envision estates and trusts, because there's so many complexities, so many different directions.
Yeah.
But one point of confusion that I've heard over the years, and I will say you're absolutely correct that attorneys and their clients hire us all the time to run projections, tax projections, or tax consulting for these type of situations, and so we welcome those. But anyway, that aside, one thing that is kind of a procedural question is, let's say you have a family member and that family member unfortunately passes away.
Yeah.
What are the steps that you take as attorney at that point? You've been kind of trusted to be the attorney for that client's
You
assets.
mean
So
if my client passes away, right?
correct, your client passes away. What happens now?
So yeah, I mean, first of all, it's always devastating. We just had our client, 40-year-old woman with 12-year-old daughter, passed away just yesterday. So we got this devastating news. But what happens, like, hopefully we had a chance to set up revocable trust or some kind of mechanism to keep all the assets and everything else outside of probate and outside of court involvement. So hopefully we have, by that time, we already have a trust established and all assets are funded or connected to the trust. And the person who passed away already got their wishes, and we put them on paper, how they will be distributed and to whom and under which condition. So hopefully we'll stay out of the court, so the client can save court fees, on attorney's fees, on all these delays, and and beneficiaries can get inheritance pretty often right away, or have access, so the trustees can start managing the trust assets.
What
So
about in
they-
situations where you have the trust assets and now you're the law firm that's in charge of managing these trust assets? What are the situations that result in that? Because I've seen ones where it's for years that there is some type of an entity set up for years, and the attorney's involved, and there's distributions involved, the beneficiaries are involved. You have to
You
have
mean this? Yeah, that's what George. We don't serve as trustees, not in my practice, because I'm still growing. We only have 2 attorneys in my practice, but we do serve. Like, we even have it for each of our clients after who drafted the trust with us. If someone passes away, they come to us. We have a successor trustee session. So we look at the documents and see what the documents call for. Do we need to do any split? Do we need to draft a new certification of trust, and provide step-by-step instruction to the trustee? And usually trustees are trusted people who our clients appointed. We do not serve as trustees at this time. We may serve in the future, but we represent trustees to make sure that they follow the wishes, they follow the trust document, and they contact CPA to pay taxes and make sure that they are in compliance. We in our administration, we call it trust administration. We have couple trusts like right now, and one situation unfortunately, I think that's what we learned yesterday about this woman is going to be same situation, but in one situation there was a young child and single mother who passed away, and she happened to find a really good trustees who were her friends, and they're trustees for so many years already. And now when daughter graduated from school, from college in New York, now they're ready to dissolve the trust because trust said, okay, when she graduates, when she turns 23, blah blah blah, so she can be in charge of her own assets. Like, so they've been through with this trust for 7-8 years. Each year we would have like a meeting, and if they had any questions we would answer them. We would connect them to CPAs and other professionals, but they were so good in taking care of the little girl who was left without mom. But and then we have some more complicated trust settlement cases where we need to do some split for tax purposes, for maybe like file some Maryland and federal tax returns. But that's when we engage tax professionals because
what happens if the trustee that's chosen by the state does a bad job? I mean, what happens then?
oh yeah, I mean, it's like always we've heard about these stories. One with during the initial consultation and during the consultation that leads towards the signing of the paper of the trust and other documents, we discuss this with clients. And for some clients, it's an easy fix. They're gonna just say, okay, we have contingency. We have 1, 2, 3, 5, 7 people, not seven, but like usually I'm asking about for 2 or 3 names who can be the trustees if the primary trustee cannot or may not serve, or for any other reason is not a good fit. We have some mechanism in the trust, and that's what we discuss with each client, how we can remove the trustee if, for example, beneficiaries are concerned that something isn't right. We also have a mechanism to appoint a successor trustees if one is not appointed. But for some clients, it's really an issue. So they say, we don't have any family, we don't have any trust, any friends with trust. So they may go and ask for professional trustee, which is not my favorite choice, because it's usually the trustee doesn't, professional trustee, they don't know the family, they don't know what you wanted. But sometimes people, just they cannot find the trustee and call one name, and
Well, what are the kind of fees that people can expect for either
there is
a
actually a
personal one or?
table in Maryland law that trustee can, and you can even calculate how much the trustee can get for the services.
Mhm.
Besides, they're getting a flat fee, for example, for the amount in the principal that for them to manage it. And then they also collect fees for every distribution they make. So it can become really expensive, and everything below there is a schedule. Sometimes the clients say, okay, we're gonna follow the schedule that is provided by Maryland law. If they engage professional trustees, they have their own schedule. That's why it's always best to, I guess, find the trusted person, couple people who can manage the assets in case you cannot manage, and then successor trustee cannot. And so we have 2, 3 names in that order. We also I like utilizing provisions about trust protector in trust documents, which means that it's an individual or a law firm or maybe CPA firm that can appoint a trust protector who can appoint a trustee, in case one is not appointed or another trustee cannot serve. Or some people, they say, okay, we would like to appoint as trust protector an individual they trust who will be looking after trustee. Maybe once a year requesting all the financial documents to check how they're going, you know. That's why I guess trustee is called trustee, because it comes from the word trust. So you
Mhm.
have to find someone who you trust, and hopefully the person will be doing, and actually don't forget that many clients, they would request in a trust that will put provision the trustee who serves will be fiduciary, yeah, so we can put these provisions as well, but explaining to the client that, look, sometimes, like if you put this provision and require trustee to be fiduciary, which means that they will be kind of responsible under the law to make everything in the best interest of the beneficiaries and can be, some consequences. But for example, professional trustees would not want to serve if they see this provision, unfortunately, sometimes. So it's like, that's why, like when we talk about estate planning, it's several conversation. It's like you learn the family, you learn their assets, you learn their goals and values. And then you can say, okay, if the family doesn't have close friends or relatives here, it's really hard. But then after couple consultation, after couple initial, talks, they say, oh, let me appoint, for example, someone they remember, or they spoke to someone, they say, okay, I think this person should be good. And actually a combination of people. And like someone can appoint their sibling who may not be very good with money, serving along with a friend who is good with money. So, and that's what we discussed. But I would say that it's one of the most difficult questions people have to decide. My clients have to decide who they appoint as a successor trustee to make sure that their wishes are carried out.
Yeah, it's very difficult to find that kind of person because they need to know the family, they need to know the values, they need to know everybody there. So it'd have to be a very close friend or relative. But some people just they might not have that. So I can
And
see
it's
how
a
that.
lot of work. It's a lot of work. It's overwhelming, even for law firm. That's why, like we're not in a rush to serve as trustees. It's a lot. It's a lot of responsibility, a lot of yeah, and sometimes it's a lot for a person to handle, and it's nice if the people who are providing for the beneficiaries, they also provide enough funds so the trustee can hire professional. The trustee doesn't have to be by himself or herself and trying to understand what's going on. Even we provide with all instructions, all step-by-step instruction stuff, it's still a lot. So it's okay for the trustee to go and hire an attorney, to go to hire a financial advisor or CPA to make sure that he's doing the right thing and trying to provide for the beneficiaries and as a reasonable person would do. You don't have to be really saving in money, but you have to be a trusted person. That's for sure to be trustee.
Got it, got it, got it. Well, look, this has been very productive. I think you answered a lot of common questions that my clients have. But what I can tell you is, if we stayed for an additional hour, we can still have more and more things to talk about. Just
Definitely,
because.
like I wanted to talk about probate and about all other stuffs, but it's actually, thank you very much for all these questions. And actually, like it's why I always like value this kind of conversation, because it's one of the ways for me to tell like to the people, just like try to take control, try to plan in advance, so engage the person you trust, so you can make sure that your legacy is carried out and that like your beneficiaries are provided the way you want. And estate planning is not only for wealthy people, it's for people who just want to be in control and who want to take care of their of their beneficiaries, of their family members, to provide family harmony and like to make sure that everything is the way they want it.
Thank you so much, Irina. It was a pleasure
Yes,
having you here. And what I'll say is a few final words is you can get in contact with Irina. We'll provide her contact information at or around this video. Same thing for me. What others other than Maryland State, Irina? Do you have any other states that you work in, such as maybe DC or Virginia, or are you strictly Maryland, or which states do you guys work in?
yeah. For now, we focus on the state of Maryland because we're already all very busy, but we do take DC clients as well. And we working with pleasure with other attorneys from different states. If, for example, clients or their assets in the various states, we work with Florida, with South Carolina, North Carolina, Delaware. So, in other states. But our practice is mainly in a state of Maryland, and we serve Maryland clients. Okay.
Sounds good. Okay, well, you know where to for our audience, you know where to reach us at this point. And so it was a pleasure having you on the call, Irina. We'll have your
Thank you,
main.
George. I appreciate it. Thank
Thank you.
you.
Thank you. We'll speak soon. Thank you.
Bye.